Verdict watch day two. Verdict watch day two. Some activity today. We could read into it a little bit. I'll get to that. Great to see everyone. Here we go. A little bit of sniping inside the courtroom today. A little back and forth. Judge had to make an important decision. I think we can glean a little bit into some of the things that the jury is considering. And I think, some people now start to wonder, oh my goodness, what is going on here? Why is it taking this jury so long? What could they possibly be doing? What is so hard about this? Well, it's hard. It's hard for 12 people who don't know each other, who never met one another, to come together and all agree in a case where both sides are making important arguments, and they know that the decision they're going to make is important and how it impacts so many people. They take their job seriously, and that's what's taking place in Dedham, Massachusetts. All right. Now, where do we begin? Where do we begin today? Do you want to begin with the verdict form? Because this was fascinating dynamic, fascinating the way it turned out. Like I said yesterday, and I said that the jury gets an actual form that they, an actual form that they fill out. And that's how they reach a verdict. Like you basically, the foreperson, whoever it is, will fill out a form, put a little check mark or whatever is asked, and then sign it, and then they hand it to who gives it to the judge. The judge reviews it, and then the clerk will likely read it. So that's how the verdict is delivered, like in real terms, like not like the voting, the discussion, all this. No, they deliver a verdict by literally delivering a verdict to the bailiff. Right? And it's a written document. So what's on that document is incredibly important, right? If you're filling, and for the most part, verdict forms are like multiple choice questions for the jury. And the choice is usually relatively simple. Sometimes gets a little more complicated in the penalty phase of a ultimate punishment case. Sometimes there's, they have to find aggravating factors, mitigating factors. In a sentencing phase, it gets a little more complicated. Sometimes they have to find specific factors that may take a crime and escalate it somewhat based upon their findings of fact. But let me do this. Like, ultimately, the verdict form is about two things. It's about guilty or not guilty and guilty, right? That's it. So something that the defense had a problem with on the second count, the judge added two lesser included charges, meaning, so there are offenses that have similar elements, but some offenses have more elements than others, but they're sort of the same conduct, the same alleged conduct with different level of elements that are required to prove. So these lesser includeds are less serious crimes. They're still serious crimes, but less serious crimes under the same theory of that charge. So in the manslaughter charge, there's two lesser includeds. The problem with the verdict form was, on the top, it had like the charge of manslaughter, and it had, not guilty or guilty of, not guilty of the offense, guilty of the offense. And then underneath it, it had two lesser included charges, which had just a line next to it that said guilty. So you only had the option to check guilty on those lesser included offenses. But what if you're finding KarenRead not guilty of the lesser included offenses? And this was the argument Alan Jackson was making. And to me, it made sense. Like, what do they do? Like, there's no place for them to write not guilty for those. There's only a box for guilty. And the judge's initial reaction was, well, they leave them blank. If they don't vote guilty, then it's not guilty. But that's not how it works. Like, they have to actually agree to something. Not agreeing to guilty does not necessarily mean you agree to not guilty. Like, you could be hung on that. So if you're hung on that, you wouldn't check anything. And that's basically the way it was. It was incredibly confusing unnecessarily, right? All you need to do is put it guilty or not guilty there, or clarify it in a way that the jury knows, because the way it was written, and I should have picked up on this yesterday or last night, but I didn't. I should be more, I guess, skeptical. But, these things are pretty basic and fundamental. Like, you do them at the end of every trial, which is why I was shocked that the verdict form was ambiguous. And that's really the word. It was ambiguous, because not agreeing that someone is guilty does not mean you all agree that they're not guilty. What it means is either you couldn't agree either way, or maybe you think that he's not guilty, but there's no place to write that on the verdict form. So, Alan Jackson, the defense attorney, wanted a not guilty option there. He felt it was leading the jury to check guilty. Like, if you don't find this, you got to find one or the other, right? She's either guilty of this or guilty of that. There's no not guilty option. So what they did is they clarified, based on the recommendation of Alan Jackson, the defense, on the top of the form, to add some language that checking not guilty on the top of that count two means you are saying not guilty to the charge and the lesser included charges. Still not perfect. I would rather have guilty and not guilty next to one another, because these are 12 people who know nothing about the world of law, and you want to make it as straightforward and as simple as possible for them. I think it gets the job done the way the judge has done it. I think it's better than it was, but it's not the clearest it could be. And what I think happened there was, I think you had some level of, gravitas in there, because Alan Jackson's from out of state and he's from LA. He's Mr. Hollywood, and he doesn't know the way we do things here in Massachusetts. I definitely picked up on that vibe inside the courtroom, because the judge then went to David Yannetti, who's local, and says, well, David, you know. And David Yannetti was like, well, not exactly, Your Honor. But the problem was, it was absolutely ambiguous, because if the jury hung on the question of the two lesser includeds, how would you note that? The way you note that you're hung is you don't fill out you don't check anything. So it actually probably could have helped the defense, right? I mean, in a certain way, like, if they got to the point where they were hung on the lesser includeds, but had voted not guilty on the top one, that verdict form would have sent her home as it was. So, the defense probably helped themselves a little bit by making it clearer and getting away from the way it's leading the jury to a choice of only two different guilties. But if in fact they're not guilty of the top and they're hung on those, they may have gotten away with it. But that's really deep in the legal weeds, which is never where you want the jury to be. You want them out of there. You want it clear. And I think that's one correct criticism of our system of justice. Lawyers used to get paid by the word, right? That's how we used to get paid, by the word. And that's why legalese was born, and legal documents are so clunky and don't make a lot of sense, is because when the original documents years ago were made, lawyers are getting paid by the word. There's been a push to try to make everything more simple, and it should be that way, but we get stuck in our legal ease, and we forget that the rest of the people don't practice law, don't read these legal documents all the time, and aren't used to the vernacular and the ridiculousness of the way we phrase things in the world of law. I mean, it is ridiculous. You read laws, they're ridiculous as well. Nobody, just plain English should work. Like we could rework every statute, every jury charge into some plain words, but we don't, because we're lawyers and we forget, and we just forget. So the other part of this was that it was there was absolute friction between the judge and Alan Jackson, and then KarenRead, who apparently, while the judge is denying Alan Jackson's request for a not guilty choice on 2 of the charges, she smiles, in her KarenRead way, like, yeah, of course, this is what's happening because the fix is in. I can't believe this again. And the judge called her out on that. And that was an interesting moment. But as we know, shortly thereafter in the day, the judge sort of backpedaled a little bit, actually a lot, didn't admit that she was backpedaling, but in the end acquiesced to Alan Jackson's request, because I think you take a moment to think about it and you're like, oh yeah, I think we need to do that. Because what's the impact? Like, if she is found guilty of one of those lesser includeds, that's automatic reversal on appeal. Like, the appellate court looks at it and says, you mean the jury didn't have it wasn't clear to the jury that there was a choice of not guilty on these 2 charges? Yeah, we're gonna have to do that over again. So that's what happened today. That was the drama inside the courtroom. You also had the jury. There was, I think, one juror who had a prior commitment for today. Now, this is interesting as well, right? So one juror has a prior commitment and they all agree we're going to leave early. If we don't reach a verdict, we're going to leave early. And they left very early. They left even before 4 o'clock today. So at the end of the day, where you end up is a jury that is getting along to the fact that, hey, one of us has a problem, then all of us have a problem. And that was good to see, because a jury wants to get done. They want to work. They want to finish. They want to reach a verdict. They do want to reach a verdict. A jury takes that upon themselves, that they feel like they fail if they don't reach that verdict. So they will do it. Now, let me get to one of the substantive questions from the jury, because I think this is significant and may give us a little insight into part of what they're doing here and what they're considering. They said they wanted the report from the CERT team. The report or reports from the CERT team. This was the emergency response team that came to the scene and was doing the search and was finding the evidence, like pieces of taillight, like the shoe, that were doing the dig. There was the team that was doing this search for evidence. So why is this important? Why is this significant? Well, first of all, they wanted the reports, right? You're not getting the reports. The reports are hearsay. They're out-of-court statements. So they're not admissible. They're not evidence. They can be used during the course of testimony to refresh recollections. They're allowed to review them and then answer questions, but they are not evidence in and of themselves. So with that in mind, the jury's not getting them. Now, it'll be interesting to see if the jury asks for any readbacks of testimony along those lines. But this becomes an important issue because the CERT team is finding evidence. The defense is alleging that evidence is being planted. So I think the evidence at the scene, the pieces of the taillight today were on the agenda of this jury to try to figure that out. Right? There has to be some level of debate going on right now about whether or not the evidence was planted. That's why I believe you would ask for the CERT reports. You're trying to figure it out. You're trying to get to the bottom of it, and you're having a discussion inside, and maybe you say, well, let's take a look at the report. What do the reports say? Well, let's find out. Let's ask the judge for the reports. Let's get those. No, you're not going to get them, but the conversation will continue. So if that's one of their focuses about whether or not the evidence was planted, okay, well, that's kind of what this trial is about. That's really what this trial is about. Because if you accept on its face all the prosecution's evidence, it's obvious that she did it. That the car struck John O'Keefe. If you accept their evidence on its face, but if you don't accept the evidence on its face, then you want to examine the circumstances surrounding the evidence that was found and was used in this case. And specifically, stuff from the scene is most important, right? The actual pieces of the tail light. Like if you believe that they're planting pieces of tail light, then that's likely not guilty. If you believe that's ridiculous, that they didn't even have an opportunity to plant that evidence, then you're leaning towards KarenRead is responsible for what happened to John O'Keefe. So this is an appropriate issue. I think it's right on point, this issue, and goes to the heart of the case. Now, there's a lot of other ways to get into that, but getting to the actual search. And this is where on my show, there's been a great debate about whether or not there was actually a window of time or an opportunity for this evidence to be planted. And you saw both sides going through their timelines during their closing arguments and became a big part of the evidence in the case. The timeline is clearly and closely aligned with this issue because you need an opportunity to do this. And what information in those reports would clarify that for the jury? Reports, again, that they will not be getting. So there's some level of debate, and you never want to overread into any sort of question or debate that the jury has, because sometimes it could be a split down the middle and they're arguing. Sometimes there could be one person holding out on either side, and they're like, all right, let's convince this guy or this woman. Let's get that piece of evidence in here. That'll convince you. That report. We'll show you the report, and then you'll be on board with the other 11 of us. So you don't know. And I've seen instances where some of these questions and notes that come from the jury are a little misleading, where we will overemphasize the level of conflict in the jury room when it could just be one or two people, or even one that's like, well, yeah, I'm with you, but I'm not 100% sure kind of deal. Or it could be someone that's dug in. So you never really know. What you can glean from it, though, is that this is an issue they're looking at, is the search at the scene. And we all know from watching the case and listening to the testimony and the evidence, the significance of the search and the significance of that moment in time in this case. So I think this is indicative of a jury that is doing their job. I think this is an appropriate place to be. I think this is an appropriate place to look for more evidence if there is more evidence. If it's not clear or there's not agreement by the jury. And I'll tell you something else. At the end of the day, sometimes the jury doesn't get everything that they want. I remember trying a case and the jury sent out a note asking for phone records. And there were no phone records in the case. It had nothing. Well, it had a little something to do with the case, I guess, in the eyes of the jury, but they were never, we didn't use them. We didn't subpoena them. We didn't have them. The defense didn't have them. So we sent the jury back in without them. But the jury wanted them. The jury wanted those phone records. So here they want those reports. They're not going to get them. They could still reach a verdict. They absolutely can still reach a verdict. But we know to a certain extent, at least part of the focus of the deliberations today. Great to have everyone on board. Live streaming, over 7,000 already. Live on Facebook, YouTube, Twitch, and X. There is a new poll up. I put up a new poll today, a little more specific. It's not just a guilty, not guilty poll. That one, 87-13, not guilty on X and on YouTube. More than 15,000 votes, whatever it ended up being. But what the one we're doing today is more about, it gets a little more specific about what you think actually happened here. And I've broken it down. I want to read it into 4 choices: intentional by KarenRead, accidental by KarenRead, a conspiracy cover-up, or I still don't know. I still don't know. So we got the poll up. Got over 3,000 votes, and this is amazing. 67% conspiracy cover-up by people in the House. 21% still don't know. 10% say accident, and only 2% intentional. That is very, very illuminating. Let's see. I did the same one on X. Let me see how we're doing on X. We don't get as many votes on X, but let's see. It's about the same. A little lower on the conspiracy. 60, but there's less votes. 60% on the conspiracy. And then it's a split between accident and I still don't know, 17 apiece, and then 5% on the intentional. So I put the links. I hope those links work in the chat. If you want to vote on that, and I'll keep it up. I don't know how long they stay up on YouTube. These polls published. I don't think it asked me how long to keep it up, so I think it just stays there, I guess. Oh, I know. The one on X expires in 23 hours. Let me see if I can extend that. No. Change by mute, add, highlight, pin. No. Can't do anything about it. All right. So it is what it is. It is what it is. All right. All right. Yep. Those are the numbers. Okay. I was just double checking on those. Getting close to 7,500. If you're on Facebook, please share and follow. If you're on YouTube, the drill is easy. Like. I mean, we've got thousands and thousands. We need to hit the like button. Hit the bell so you get alerted when I'm on. If you want to watch, if you hit the bell, you get the alert. And please don't forget to subscribe as well. All right. So that's sort of the headlines from today. The friction, but the judge did what the defense requested for the most part. You had the jury requesting something and the jury leaving a little early today because of a prior commitment. But I see that as a positive in that the jury is cooperating with one another. They're getting along. So I think that's important. All right. Where are we? I'm trying to scroll back up to the top here to get all those comments in. So they'll continue tomorrow. Personally, based on Politan's theorem, which I've gone over many times. Where'd it go? Somebody took my theorem. My theorem was here. Got it. That's my theorem. So calculating my theorem with respect to how this trial was conducted with relatively short days and a lot of half days, 30 days of testimony and I don't know, 1, maybe 2 days without the jury there, plus the half days. I'm estimating this is about, around 20 or so full days of testimony, which is 4 weeks, which is about 4 days of deliberations, Tuesday, Wednesday, Thursday, then Friday. Obviously, Tuesday was a little short, but I will compensate with that by adding what I call the Friday factor. The Friday factor. Friday speeds things up. There's something about a Friday. Court TV covers high-profile trials. That's all we do. They're all high-profile. 70% of our verdicts are on Fridays for whatever reason. It just works out that way. I believe there is a Friday factor where the jury really gets down and says, all right, it's Friday. Today's the day we wrap this up. We don't come back next week. We're going to figure this out today. And oftentimes that'll speed them up a little bit. So I'm looking at Friday after lunch. If we get past that, then I think you may have, it starts to become long. Once we get to next week, and if it goes to the middle of next week, that's a long deliberation. I think it's easier to say not guilty than to say guilty. So I will in a case like this, the most serious of all charges. I think it's easier for a jury to say not guilty, but for this jury, it might be a little difficult because they were looking at John O'Keefe's family day in and day out every day. So there is that connection to the case, that this is real, that there is someone who lost his life, and there are lives that are impacted forever as a result of it. They want to do their job, they want to put in the time, and they want to deliver justice if they can. So there were some questions about whether they're still deliberating. Darcy right here. Nope, they're gone for the day. They left early. They all agreed to leave early today. All right. Going to get to some of these. Gen X, Nelly, and of course, Frankie Figs all in on it. Here we've got the polls. You can go to YouTube or to X for the poll. You cannot go to Facebook because Facebook doesn't allow you to do it on your page. You have to do it inside a group. So we have a poll on X as well. So there you have it. All right. And Bo Peep just voted for me. Thank you, Bo Peep. Select for me. And of course, Salty Bird loves this group. Good group. Well-behaved group. Well-behaved group. And that is a leading question. Of course, we're going to. All right, let me get to some of these comments as I scroll. All right. So I will say this, though, because we've seen cases with very fast verdicts in the past. One involving a former football player, one involving a lawyer down in South Carolina. This is not a super fast, like a super fast deliberation would have been today, right? Because yesterday would have been extremely fast, right? But today would have been fast, would have been super fast. Here's Melly. Hello, everyone. Hit the like, subscribe, share, do all the things that help us out here to grow the community. Don't forget to tune in to Closing Arguments tonight. That's my show, 8 o'clock on Court TV. 2 hours unscripted coverage of this case, including a live report from Canton, Massachusetts tonight. Matt Johnson, our crime and justice correspondent, is, of course, there in the middle of it all. Martha makes a great point. It has to be difficult to make these decisions. Of course it is. Of course it is. It's very difficult. Frankie Fig saying hello to everyone. Here we go. And Jackie M., your opinion on why this jury hasn't been sequestered. I'm surprised since it's so high profile and so much media coverage. Sequestration is very rare. In the state of Florida, in the cases with the ultimate punishment, oftentimes during deliberations, they will sequester a jury. So that happens. O.J. Simpson was sequestered for 9 months. That was absurd. Most cases, most trials, we do nothing but high profile. Overwhelmingly, most of them, no sequestration. It's expensive and it's a burden on the jury. They're away from their families. They're completely isolated for 3 months from your family for your civic duty to get your, $20 a day. That doesn't seem right. That doesn't seem fair. So the jurors are instructed not to look, not to read, not to speak. Then they're asked, did you look? Did you see? Did you hear? Did you speak? And they've got to answer those honestly. And there has to be some level of trust with our jurors. There has to be. I'll tell you one thing that sequestration does, though. There have been cases with sequestration, and I did a little unscientific analysis of them, and there's an inordinate number of not guilty verdicts on cases where jurors are sequestered. Interesting, right? Like Zimmerman. Zimmerman was that was a sequestered jury. Anthony was a sequestered jury. They brought him in from another county, put him up in the hotel. We know how that ended up. And there's other ones as well. OJ, sequestered, not guilty. It just seems that sequestration gets you closer to not guilty just through the fact of sequestering the jury. Something happens to them. I don't know. Might be good, might be bad. Depends on the facts of the case and what really happened. But thank you, Jackie M. Most of the time, they are not sequestered, but they're always instructed and they're always questioned each and every day by the judge. The judge is careful to put that on the record. Allison White, finally, Alan stands up to the court. When the jury is in, he has to be so nice, finally standing up to this judge. Well, this was a big deal. This was a big deal. When you believe it's a big deal, you have to stand your ground to a certain extent. You have to remain respectful. That's just the decorum of the court. But you also, as a defense attorney, and prosecutors don't have to do this, but defense attorneys always have to make a record. Whenever they see anything happening in the court that they believe could be prejudicing their client, they need to make a record of it. Because if you don't say it and the court reporter doesn't write it down, doesn't record it, then it doesn't exist. And if you don't object or raise issues during the trial, many times you'll be prohibited from raising them on appeal. So that's why they always make a record. But like this one doesn't seem like it was necessarily or should have been a close call. I'm going to bring in some locals tonight on my show, second hour, and I'm going to ask them about that, obviously, one of the issues. But to us, I cover trials all around the country. I mean, is that the practice in Massachusetts that you have only a choice of guilty next to a charge? Like that seems a little. Well, they did have the Salem witch trials in Massachusetts, but you have to guilty and not guilty, or not guilty and guilty. Usually the argument is which comes first, not guilty or guilty. Here, not guilty comes first. Which is the way it is in many jurisdictions. But that's usually what the argument's about, not like you don't have the choice of not guilty. Like the not guilty is presumed by not voting guilty. That didn't make sense to me. Laura Wagner, how stupid to antagonize the judge, crazy. Well, if you're talking about the lawyer and you're arguing a legal issue, it's not antagonizing necessarily. It is like you pick your fights, right? Because you can, lawyers and judges are just lawyers with robes. That's who they are, lawyers with robes. Lawyers disagree, and there are debates and arguments about legal issues all the time. And judges have to make those decisions. That's their job. But judges aren't anointed necessarily with, superior legal knowledge and skills and analysis. That's not how people become judges. In some states, they're elected. It's politics. In some jurisdictions, they're appointed, which is still somewhat a political process. It's not a case where you take a test to become a judge, like who scored the highest on the bar exam becomes the judge. And that doesn't necessarily happen because the one who scores the highest is probably going to take a super high paying job somewhere in the world of law, not a lower paying job as a judge. So that's why a lawyer can firmly disagree with the judge on something that they are very sure about. And this, I think, was one of those issues, which was extremely important. Now, if you're referencing the antagonizing, which is KarenRead smiling and perhaps smirking at the moment of all that these arguments are being made and decisions being made by the judge, that's something else. That's absolutely crazy. And the reason is, you don't know what the verdict's going to be. And it could be guilty. And it could be guilty of a charge where the judge has discretion on how to sentence you. Sometimes very wide discretion. So at some point, her liberty and the amount of years that she's going to spend behind bars could be in the hands of this judge. which is why, as a defendant, you don't want to do anything to antagonize the judge. And I agree, Laura, that part of it is crazy. The lawyer legal, not so much. The defendant, who could be found guilty of a crime where the judge will decide, well, maybe it's probation, maybe it's 5 years, maybe it's 20 years. I mean, it's your life. It's in your interest. You got to do the gaga. You got to do the gaga in court. What? My poker face. The poker face. Never too happy, never too sad. Don't put your emotions on your face, especially when it comes to something that the judge is doing. Judges are people too. So, Laura, thank you so much. Great point. And we're scrolling. And Bridget, they would have cleared all this up if they just put the word or after the not guilty tick box. Duh. Well, so there's not guilty or guilty for the charge of manslaughter, but then there were two charges underneath the manslaughter, the lesser includeds, which had a line next to them for guilty. One line of guilty for each one instead of a choice. Yeah, right there you could have put a choice, not guilty or guilty. And in 2 seconds, everything's happening. All right, let's take a moment. Anne-Marie B., how late am I? Well, I'm looking, you weren't that late at the time this happened, but she was chasing a hawk away from my chickens with a broom. My neighbors must think I'm crazy. I need video of that. We need video of that. We absolutely need video of that next time. So please put up a Ring camera and don't erase the video. Marissa Charles, I'm confused as to why the DUI is included in the charges. It wasn't particularly of too much importance during the trial. Well, there's DUI resulting in death, right? DUI resulting in death. That becomes a lesser included in all of this, in the manslaughter part. It is relative, and it is important to have it in there. And there was evidence of drinking. So if there's evidence of drinking, the jury can come to that conclusion. But just a straight up DUI, obviously not a big deal in light of everything that we've been talking about here. But the reason it's in there is because it's a lesser included relative to the homicide. So there's much less exposure to imprisonment for that charge. Jen N. Hi, Vinny. Thank you for your refreshing and thorough commentary on this complex trial. Thank you, Jen N. I'm trying my best. Okay. There's also a typo, lesser charge instead of lesser. You know what? I'm horrific at spelling, by the way. I'm horrific, which is one reason I love being on television, because spelling doesn't count, right? For me, the people that put the little words underneath, well, they've got to get the spelling right there, but I don't. Yeah, that's sloppy, right? That's sloppy. Verdict form should be pristine and perfect. Kathy Guidry, Judge Beverly was tired. KR reacted. I would have too. I get it, because at the end of the day, the judge is there, the lawyers, everything else. There's only one person at the end of this who could go to prison for the rest of her life, and that's KarenRead. For the victim's family, they never get back their loved ones. So for them, the loss is permanent, and there never is closure. But for the defendant, there's one decision versus the other. There's a lot at stake here. I mean, everything's at stake. And she's reacting. She reacted throughout. That's who she is. And might be one of the reasons why she didn't testify. Because people would have a very perhaps polarized view of her reactions. Up to 8,500 Everybody waiting for a verdict in this big case. Big girl for life. The traffic in Massachusetts is all KR's fault. My guess, they will hang or involuntary. This case is unreal, Vinny. Play us the moment KR got called out. What's interesting, the moment, and we'll play it for you tonight on the show. But the moment, I don't think you see her. I was watching. You might see her just afterwards. I have to take a closer look at it. But I remember because Alan Jackson was standing up and she's on the other side of Alan Jackson as this is taking place. But I think at some moment she does lean back. So you'll see it tonight. You'll see it tonight. Ooh, green-eyed Southern girl. Nah, they may be sleeping on it. Correct. Don't forget. But they did set this time. They did set this time that they were leaving early. So it's not like they reached the verdict early and said, let's get out of here. They were getting out of here early today. They needed to get on the shuttle bus and get out of there because one of the jurors had an appointment. So they could be sleeping on it. I just feel like it would be too much of a coincidence for me that the time they reached the verdict was also the time that they said they were going to end for the day and they're going to sleep on it. So I don't think they're sleeping on it tonight. But again, it's my conjecture based upon some of the circumstances. SW 4x4 Explorers. If hung jury, do they retry it all again? Yes. Yes. Hung jury on everything means that everything gets retried. Now, there could be a partial verdict. They could find her not guilty of the top charge, but hang on a lesser included or hang on the second count. So you could have a partial verdict where then all of a sudden the top charge is off the table. Like we've all agreed that it's not that, but we haven't agreed about manslaughter yet. And that can happen too. And if that happens, then the retrial would just be with the top charge of manslaughter because of jeopardy, double jeopardy. If they find you not guilty of something, even if it's only a partial verdict, that partial verdict stands and that count now disappears. I've seen that happen. And the retrial is a different case because you're not being tried for that top count anymore. And that could happen here. That could very well happen. June. Hi, Vinny. How do you know how Karen laughed when it wasn't recorded? Exactly. We don't. We don't know. We don't know. Like I said, she may have leaned back afterwards, but in the moment, I didn't see her because I saw Alan Jackson's body. But the judge saw it, and the judge reacted to it, and we're going by the judge's description of what she saw. True after dark. How about that verdict form, eh, Vinny? Yeah, it's problematic. It's problematic. You got to get that right. Verdict form's got to be right. It's got to be right. It's got to be clear. It's got to be proper. And it's got to be easy for the jury. Some of them aren't. And again, it's because of us lawyers. We've done that. Lawyers and judges making rulings and language and crossing this out, put this over here, put that up here, add this clause in there. Have you ever been in a contract negotiation with anyone and lawyers are involved? Nature of the beast. The Murfettes with us tonight. Can't believe the jury is still deliberating. I can. If this is a classic traditional deliberation, I wouldn't be shocked until we get to like Monday afternoon. Then I'd say like, all right, this is getting a little long. It's getting long. Now you might not believe because you expected a super fast verdict. If you were expecting the super fast verdict, then I can understand your disbelief. But just general disbelief, no, because this is not a long deliberation yet. Little mystery. Vinny has great mods. Melly, Gen X, of course, and Frankie Figs. Ooh. AUIE. AU. No cert report equals no evidence. No, you have testimony. You have testimony. You have to rely on the testimony. Reports generally, it's rare that a report gets in as evidence. Sometimes they can under a hearsay exception, business records, something like that. But generally speaking, these reports do not become evidence. The evidence is the testimony of the people who wrote the reports. Mm-hmm. Let's see who else is here. The Mike D experience, paddle in hand on the river, fighting the rapids. Great coverage. Thank you. Thank you, Mike D. Stay safe there. You're not wearing floaties. No life jacket, no floaties, Mike D. Living on the edge. Laura Hatton, there was no crash. And our chief shenanigation officer is just listening. Oh, man, going to miss Vinny's face while I'm walking the dog and just listening. Well, thank you for listening, though. Thank you for listening. Appreciate it, Chief. Appreciate it, Chief. Mm-hmm. Who else? So basically, the way I start like I do my half-hour monologue off the top, and then I'm a half hour behind in some of the comments. Here's Heisenberg. Let's see what's going on. Vinny, if John were really beaten by 3 people, they wouldn't need to frame her. They would simply say the beating was in self-defense and vouch for each other. None of that took place in court, says Heisenberg. Well, yes, you could say self-defense, and then you'd have the other witnesses testify about it. There would be no video of it, but there would be eyewitnesses, right? I get that. Now, I want to address this in a different way, right? I think another part of the whole situation here, and I think part of what the defense was alluding to with the blue wall and all that, is that an officer losing his life in another officer's home becomes a problem and a scandal. And we need to avoid that. And I think that's part of what they sort of were arguing here between the lines a bit. But I get what you're saying, Heisenberg. Would that be a more effective way to do it? To concede that it happened here, but hey, it was self-defense and he fell down the stairs. And if that's the case, then you got to call 911 immediately, which they didn't do. But at the moment, they could have thought to do that. Or did they panic? Or did that not even happen? Right? Thank you, Heisenberg. Always on point. Okay, some people are asking for it. Gen X has it up for us. This is the new poll on my community tab. So you got to go on my page, and you got the link right here. And the poll today is more about what you think happened here rather than just a straight guilty, not guilty, because guilty, not guilty doesn't fully answer what you think happened. This question gets more into it, and I'll read the questions, and then I'll give you the current results, which may or may not shock you. And we're over 5,000 votes, so it's starting to lock in. The numbers are starting to get firm right now. Do you believe it was intentional by Karen, accidental by Karen, conspiracy by the people in the house, they're responsible, or I still don't know? Conspiracy still way ahead, 68%. And if it's 68%, then it's not really a conspiracy theory anymore, is it, right? 19% don't know. Okay, 19% don't know. 10% are saying accidental. Only 3% agreeing with the prosecution's theory and allegation here. And that's on Facebook. And let's see how it's doing on X right now, because we have it up on, you can go on X as well. And on X, the numbers are a little different, but not much different. Conspiracy, it's 60. I don't know, 17. Accidental, 17. Intentional prosecution theory, 5%. So a little bit higher on the intentional on X than on YouTube. But interesting analysis, right? Interesting. And here's the link that you can go to it. Thanks so much, Gen X. All right. Yeah, only 2% believing the prosecution's argument. That's bad. Injuries just don't add up to car hit. Also kind of surprised so many people think deliberations are taking too long. It seems normal. In my opinion, NG, lots of RD. That's not guilty with lots of reasonable doubt from Supernova 42. I agree. It's not taking too. It's not a long deliberation yet. It's just not long yet. It's not long. It's just not fast. So where does that leave us? By the way, we're getting close to 9,000. Please hit the like button. Please share it on Facebook. Like button on Facebook. Let's see if we can hit 9,000 here. That'd be amazing. Okay. Are there mean people in the chat? I saw some people. And here's Melly showing us the link to X. Muffin Cooper. If everybody that left furious voicemails was guilty of murder, we'd all be in trouble. Yeah, I don't think the prosecution is necessarily pointing to these messages as proof of guilt, but evidence of the nature of the relationship and her state of mind close in time to when they say this happened, and potential motive. But something after the fact, how do you prove motive after the fact? Motive, you have to prove actions before the fact. That's the way I look at it. That's the way I see motive. Michelle L., I think this jury is taking its time to make sure they get it right. The logistics alone are a lot for 12 people to agree on. I'd be doing the same thing. That's more than I can say for the investigators. A little dig at the bias of Trooper Proctor from Michelle L. Thank you, Michelle L. Let's see. All right, CW, Vinny, what was the longest and shortest deliberations that you have for your cases? We've had, trials that I don't remember the names of them, but we've had verdicts in less than an hour. But they were short cases. OJ was 9 months and it was I think less than 3 hours. So that's super fast. Murdoch, less than 3 hours, a month and a half of that trial. So that was fast. But I've had ones that are, less than an hour. So that would be the shortest. The longest for me was Rabbi Fred Newlander. There was another one that was longer. I was working at Court TV. I don't think I was an anchor yet. And I was a correspondent, but I wasn't covering the trial, which is why I'm not remembering it. But the longest for me, this was a trial I was a correspondent at. Rabbi Fred Newlander in New Jersey. The trial was only a week. The jury deliberated for 2 weeks. The deliberations were twice as long as the trial. That jury was hung. He was retried and convicted, but they ended up after 2 weeks not being able to agree. But that was the longest. It was amazing because it was a really, really fascinating trial. Every witness was you were glued to the seat for everything that every witness was saying. And it moved by very quickly, witness to witness to witness. And then we sat there waiting for the verdict, and we're like, wait a minute, we've been here twice as long as the trial. What is going on here? And we knew it was going on. I think there was just one holdout, maybe two. Judge said that the form is typical. What about others who were convicted because juries were misled? Well, that's up to those attorneys in those trials at those moments to raise these issues, right? And this is part of what you get when you have an attorney who's super bright and is not going to just let things sort of slide by where you're really looking at it. And I'm a little mad at myself for not noticing that last night. I'll be honest with you, because that's part of my job. Not to defend people, but to analyze everything and take a really close look at it. I was more interested in the substance and the elements of the lesser includeds rather than the actual form of the form. I didn't even think the form of the form would be wrong, but it was. And it's been corrected to a certain extent, which is good, because we want this to be clear to the jury. Charlie Marinaro, my paisan, do complex instructions lead to higher possibility of a hung jury? I would say no. What leads to a higher possibility of hung juries is it really comes down to the jurors themselves. And when you have a hung jury, it's really people on both sides unwilling to compromise. I think it's more in the nature of the jurors themselves than the instructions, because I believe the instructions are always overly complicated. I believe even the definition of reasonable doubt is extremely vague and unfair to the jury. But it's our system. We're over 9,000, by the way. Facebook, YouTube, Twitch, and X. Thank you, everyone. But yeah, I think that's more of a factor. I think it's the personalities and the nature of the jurors. Murfetts, thank goodness this trial was streamed. Otherwise, we would never know about this shady, incompetent decision. That's the beauty of cameras in the courtroom in general, is that it shines light on our system of justice, which is our system of justice, our government. Okay. They're not like separate and apart ruling over us. They all work for us, and it's we the people. It's our system of justice. And the Supreme Court are the worst offenders of keeping cameras out of there. It's disgraceful. There should be cameras in every courtroom across America. There absolutely should be. At this point, I believe there should be an obligation on courts to stream everything that happens inside of a courtroom publicly, except things that aren't public, like family court, juveniles, etc. But in public trials, I think at this point in our society, with the way that everything's being done remotely, by the way, that every courtroom should have cameras set up. It's not expensive. They should have Wi-Fi, and they should stream all their proceedings on YouTube. Period. End of story. And if the media requests to be in there with real cameras, they should be permitted. It's our system of justice. It doesn't belong to the judges. It doesn't belong to the lawyers. It belongs to us. They work for us. We should be able to see what they're doing day in and day out. Bart Starley. Vinny, you've been very measured in your approach. With that said, gut feeling, does this come back guilty, not guilty, or hung jury? Well, gut feeling is a prediction of what a jury is going to do, which I have admitted I am not good at. I don't know these people. See, I think we make this mistake in equating the way we feel about a case versus what a jury feels about a case, because they're different than we are. They're different. Their perspective is different, and the way they see and hear the evidence is different because they're inside the courtroom. Okay, so they're going to see and hear things that we don't necessarily see or hear. But predicting the way 12 people will interact, I think, is incredibly difficult. The best we can do is based on our experience in seeing cases like this. What would you expect a jury to do? How does it compare to other cases where you've seen juries say not guilty, where you've seen juries say guilty? So based on that, this is what I'll say. Because it's not a raw prediction, but based on other cases that I've seen, this one has more potential reasonable doubt arguments than most, including cases where people have been found not guilty. Okay? So this one has more potential reasonable doubt for a jury to hang their hat on than most of the trials that I've covered over the past couple of decades on court TV, including ones where juries did come back not guilty. So based on that, to me, at this point, I'm always surprised to hear the words not guilty in a criminal case because of the overall statistics. But in this case, this is one where I think it would be a little more shocking to hear the word guilty based upon the way the evidence came in, based upon the way the witnesses testified, based on the way the case was tried. I think it'd be a little more shocking. But there's still part of me that knows 80 to 90% of criminal trials result in a conviction. It's this small amount. It's a very small amount that comes back the other way. And that's just statistically looking at it. But looking at this one objectively, like, because reasonable doubt arguments are made all the time. Some have some level of credibility for a jury to say, oh, for me to say, oh, I could see a jury buying that. Here, I see more that a jury could buy into than in most cases, including ones where people have been found not guilty. So I'm still measured, Bart, but I think I explained my analysis of this case compared to the history of the hundreds of cases that I've covered. Charlie Marinaro, by the way, my son is Vinny Marinaro. Like, oh, is that a name? Is that a name or what? Thank you, Charlie. Albert Norda, beginning of Sallyport video. When SUV comes in, one door is daylight while rear door is dead of night. Shows doctoring right away from splicing video. All right, I don't have the video. I just have Sallyport freeze frames. So this is the same picture, but turned around to be the right way. So, so I guess where you are, Albert, is that not just was the video inverted, but more was done to it. And I think Alan Jackson argued that as well, talking about the words that are underneath, like the timestamp and stuff that's underneath it. He's claiming more manipulation as well. He did in front of the jury. Linda McHenry. Hi, Vinny. Mr. Vinny, can you please discuss Sebastian's case some more? This missing boy, he needs your help now because it's just so wrong. The circuit is. I know you can help. Love you and your expertise. Linda, yeah, we will be back on that story. This trial, at some point, the jury will come back. At some point, there'll be a verdict. And obviously, we will again keeping up with and reminding folks about this missing child in Tennessee, Sebastian. It's incredibly sad. I don't understand how someone just disappears, but that's what we've been left with so far. So yeah, we will be on the story, both here on the stream and on my show, Closing Arguments. Thank you, Linda. Thank you for caring about little Sebastian. Melly, is the verdict form issue normal? Yannetti states it differed from what he is familiar with. What is your take? Standard versus mandated forms. Now the instructions, there's there's form of instructions that judges have, that they'll have like similar instructions that they may alter a little bit depending upon particular situations in a case, but you have standard issued jury instructions that the judges in each state have according to their state law and some of the case law in the state. They've devised these recommended jury instructions. But when it comes to the forms themselves, I think it's a little more free form. I think judges use what they use. They may have standard forms, but each case is going to be a little different in terms of adding additional factors like lesser includeds that a jury has to determine. And that's what happened here, is that you added lesser includeds. And the question is, how do you put that on the form for this jury so it makes sense? And that was fixed today. So I would say, I can't imagine that it's standard the way it was originally written. All right. You know, it's interesting how how I see it. Like, there's always little side conversations trying to analyze me. That's awesome. WIG, Wig, Vinny, fellow New Jersey trial lawyer here. Okay, Wig, first of all, we have a rule here. You comment, you're from New Jersey, you got to give me the exit. Got to give me the exit. But anyway, let's continue. I'm happy to say our judges in the Garden State are far better than this Massachusetts judge. I practiced in New Jersey, and there were some very good judges. There were a couple that were a little I don't think this judge is bad. I think today was not a great moment. I think everybody's a little tired, a little cranky. But at the end of the day, she made the correction, and that's what you want to happen. But, you know, you spend 9 weeks together locked in there, plus the 2 years of litigation leading up to it. You know, it's like when guests stay over just a little too long. I think that's part of what's going on inside the courtroom. But thank you, fellow NJ trial lawyer. MW, hi, Vinny. With all the evidence in this trial, if you were a juror, how would you vote? How would you vote? That's tough. That's tough. What I've said is, for sure, on the top charge, there's no way I'm voting guilty on the top charge. I was against that from the beginning. I said I wouldn't have brought that charge as a prosecutor based upon the alleged facts. Not even the proven facts, but just the alleged facts. I wouldn't have brought that top charge. A bunch of lawyers that have been on my show have agreed on that point. I think most of us do. Thought that it was, and sometimes charges like that are made to kind of force a guilty plea to something a little less, but that didn't happen here. And then they went to trial with the charge. They still could win. We don't know what's going to happen here. They may still convince this jury. The jury may think that's what it is. I don't think that's what it was. For me, the biggest problem for me was at the end of the case. It was at the end of the case because there's two ways to look at it. There's like, my common sense tells me I don't believe there was a conspiracy. Common sense tells me that, right? There's too many people involved. Too many to have to cooperate. It seemed like a bridge too far, I guess, is the cliche we would use. Is that the right cliche? But by the same token, there's a burden to prove your case beyond a reasonable doubt. So I feel like if you're in the room with the 11 others, how are we approaching this? If we're approaching this from, listen, my common sense is telling me I don't believe this conspiracy. Okay? I don't believe this conspiracy is happening. Then where do I land? Do I land on, well, it's obvious what happened here? Or do I land on, well, did he prove it? Did he prove it? And if so, how did he prove it? How did he prove that the car did it? Was it John O'Keefe's phone? Was it John O'Keefe's phone and the pieces that are found at the scene? Is it the hair? It certainly wasn't the expert. And then there's a neutral expert saying something completely different. That's the problem. That's the holdup I have. That's what's getting between me and something in count two. Something in count two. Perhaps a lesser included, because I believe she was drinking. I absolutely believe she was under the influence drinking, like some of the cops were that night. Like everybody's drinking and driving, which I have a big problem with. So I think I'm landing on count two, perhaps in a lesser included. The one thing that could prevent me from voting guilty is how my fellow jurors are looking at this expert testimony. Like, are we convinced without it that we're discounting it? Because if you count it and I rely on it, then you can't. But if you discount the experts because they're not there, they're not eyewitnesses, they're just trying to put something together after the fact, and then rely upon the evidence that is what it is, like a phone record, like a hair, like video of someone drinking, then I think you get closer to count two. That's where my debate would be. And likely on one of the lessers in count two. But you have to overcome the expert disaster. And I haven't fully deliberated on that myself. But that's to me, that's where my focus would be in the jury room. Was that measured? I'm trying to be measured. All right. Okay. 9,200, all waiting for a verdict. Don't forget, we have the poll, folks. We have the poll, the new poll. We've got it on X, and we also have it on my YouTube page under the community tab. What you think happened? And as I read the poll today, I think it's even more devastating than the initial guilty, not guilty poll, which was 87-13, not guilty. Mm-hmm. Let's see. I'm way behind in my comments here. I'm trying to get to where's the other one? Here it is. Oh, no, that's not it. One second. Here's Beth. Vinny's on TV because he's so handsome. Oh, thank you, Beth. But that's not why. Actually, I love microphones. Mm-hmm. All right, Auntie Bev's verdict form. I'm a big deal and didn't allow it. Can't file me away in that messy file, as the appellate court would have beaten me to a pulp. That took a lot of thought there. Oh, that's funny. Carla Tate with a super sticker. Thank you, Carl. Oh, I think we're almost posing the same here. I just need a hat. No, I'm not going to go back there and put that hat on. I'm not going to do it. All right. Whack job. The jury asking for cert report means they are questioning legitimacy of taillight pieces. No cert report just looks even more suspicious. Not guilty. Whack job could be right. You could be right. The search and the pieces definitely on the table, definitely being spoken about. All right, Thal with a theory for you. The DA in the case, not Lally, wanted the FBI to stop their own investigation. They said no. Now the FBI has no reason to investigate this murder unless the victim was an FBI informant. What do you think? I don't think the FBI investigation was of the investigation, wasn't it? Like, because the feds have no jurisdiction to file charges, homicide charges in this case. Under what theory would they have jurisdiction? They wouldn't. But clearly there's friction between the DA and I believe it's the former U.S. attorney, the local U.S. attorney there. There was definite friction between those two. That U.S. attorney's gone. But, you know, back in the days of the old cop shows back in the 70s, there was always friction between the local cops and the feds when they would come in. Even on Law and Order, when the feds come in, they try to Bigfoot the locals. But I thought the purpose of the federal investigation was to make sure no one's civil rights were being violated by the investigation, or if there's a level of corruption within the police department or the police departments. I don't think they were actually investigating the underlying case because I don't think they would have jurisdiction for that case, because they don't have. They'll handle a homicide case if it's on federal land, if it's interstate commerce. You know, if a murder plot perhaps takes place in more than one state, they could perhaps jump in on it. Maybe, arguably. Usually it's like federal property, like a federal park or, you know, a government office, something like that. Thank you, Thal. There's more to this story about this federal investigation that really needs to, I think, needs a level of transparency and clarity for the people of Massachusetts. For the people of Massachusetts, the air needs to be cleared about all that. Michelle L., I agree with AJ, and ultimately the judge did too. The stakes are too high for everyone involved to leave anything ambiguous. Glad to observe the process. Thank you, Michelle L. Yeah, ambiguity does not work when it comes to a verdict form or a jury instruction. Yobi Trice, I feel like they are stuck on manslaughter. I'm not sure. They could be, but if they're looking at the cert, to me, that gets to the question of, did the car or didn't the car strike John O'Keefe? To me, that's what cert is connected to, I believe. Johanna Lua, if found guilty, is she going to claim the court conspired against her? I believe she's guilty. Right? And that's been part of the criticism of the conspiracy here, is that it just continues to expand and get larger and larger and larger. And how far and wide can a conspiracy actually go? Becomes the question. Who is involved? Where does it end? Where is the line? And that was, and while not being part of the conspiracy, you can still claim that the judge did not issue fair and impartial rulings for whatever reason. And that's, in most cases, if you lose, that is part of your appeal, is that the judge's rulings were not correct and were clearly adverse to you. So that'll play a part. That'll play a part in the appeal. Yobi Trice, can Karen still sue if there's a hung jury? Hung jury, you're back to ground zero. She's presumed innocent, but they can still retry the case. She can sue right now if she wants. Not going to win, but you can sue. The problem is, though, when you file a lawsuit, you now open yourself up to being deposed and put on the witness stand during the trial. That's the big difference between civil and criminal. Civil case, you're going to have to testify. Sarah, hey, Vinny, will you still have your YouTube live for other trials or just high profile? It's great. Thanks for taking time out of your day. Absolutely. We're here to stay. We've been covering true crime mysteries, obviously big trials. When we're in a big trial, we'll be on here, but we've been covering a lot of cases like Sebastian Rogers and Madeline Soto. On Fridays, I get together with a couple of my cohorts for the Tangent podcast that we do. So yeah, it's basically true crime in all its forms. Thank you, Sarah. Lina Rivard, love your show and insight you give. If you've said it, what are your thoughts? Do you think KR is guilty? Honest answered, not your prosecutor answer. I do have a prosecutor filter. I admit it. That's the way I see the world. I was a prosecutor, so it's hard. It's hard. It's difficult. It's difficult. I think I gave that analysis, though, of where I am and where I'm not in all of this. Okay, Debbie says Debbie Rowland, the judge was unnecessarily snarky, in my opinion. You'd be shocked by what happens day in and day out inside of courtrooms. Sometimes it's amazing. Okay, Miss Bridge, the state has all the money. KR would not be able to afford a good lawyer. Well, she has really good attorneys right now, 2 of them or 3 of them. All right, let's see. Danny Callahan, Exhibit 102 from last night's show. The taillight looks as damaged as in the Sallyport, in my opinion. I was 90% not guilty. Now I'm 60% not guilty, only because I like the glass thrown at the taillight theory. Interesting, Dan. Let me put that picture back up so people know what we are talking about. And I think we're talking about, not there. I think it's right here. There it is. This picture. I'll make it bigger. I'll make it larger. But I got to get rid of your comment right now, Dan, so we can see it. So this is what Dan's talking about. This side by side, the one on the left from 8:23 on the 29th in the morning. It's dash cam. It's a still frame from a dash cam video looking at the right tail light. Does that look similar to the right tail light and all the damage in the Sallyport? Or do you believe the snow is obscuring what you're actually seeing? If you compare it to the left tail light, the picture on the left, you can see that red going around the corner on the left, but you don't necessarily see it on the right. Is it the snow, or is it because it is in the same condition as the car in the Sallyport? I think that's an important question. I think this was an effective demonstrative aid brought forth by Lally. But despite this, the jury still wanted the cert report. So that tells me that this was not like, oh, there we go. Damage is the same. That's guilty. Nope. They're still taking a look at the issue of how the taillight pieces were recovered. Thank you, Danny Callahan. Tawanda, Vinny, the judge left first. Watch the clip. Interesting. I will tonight. Thank you, Tawanda. That's a good point. Jess, if she's found guilty, could the FBI interject? It's crazy to me that the jury is still deliberating. So Jess was expecting a very quick deliberation. That obviously did not happen. No. If she's found guilty, it's about filing appeals. It's about filing. First, you file motion with the trial court, which you'll lose. Then you file your notice of appeal. Then you file your appeal, and whether it's 6 months or 3 years down the road, you get a decision from the appellate court. And if you lose there, you try to go to the next level of the appellate court. Captain Jenks, prosecution made it confusing for the jury, hung jury, in my opinion. Captain Jenks, thank you. Always straight and clear, not confusing, right to the point. Aye, Captain. So, yeah, that's why I would always use the words, ladies and gentlemen of the jury, this is a simple case. And then my job was to make it simple. What is a CERT report? CERT report, that is a report of the emergency response team who was doing the dig, the search, the team that was there doing the search for the taillights. That's the CERT. Yobi, would you agree that Karen would have been better off not doing interviews before the verdict? I feel like she gets more hate than support from them. Yobi, I just noticed your photo that you're using. That's amazing. Funny. I think it's irrelevant. The only thing that matters when it comes to a verdict is what the jury heard in the courtroom. So someone's speaking. I really don't think it matters. I don't think it matters. And the only way it becomes really relevant is if you say something before the trial that is very incriminating and it's used against you. Tom S., to be fair, Yannetti saying, actually, no, I haven't, Your Honor, was pretty funny. Where is McSpunky? Did we see him early on? Or is McSpunky missing in action today? Bliss GB, they decided to use today to look at evidence as leaving early. Think they knew they wouldn't reach a verdict with a 4 p.m. finish, so agreed to just discuss. And that'd be a very logical way to go about your day. Yobi's back. I like you better. We than my own attorney because you don't charge me $400 an hour to answer a question. That is correct. Well, and people complain about, their lawyer bills, but how else is the lawyer going to bill you but for their time? That's the only way he can bill you. Heisenberg, one more thing, Vinny. She made all those calls and not one 911 call. Lally mentioned that big time in his closing argument. Also love your coverage and a big fan of Court TV, says Heisenberg. We'll see you in your RV, Heisenberg. The question is, will we see Heisenberg at the Baldwin trial out in New Mexico? Will you be there, Heisenberg, in New Mexico for Alec Baldwin? Russ Leary, if convicted and sent to prison, how do lawyers get paid, especially with the amount that would be due in this case? Little trick, little secret. Criminal defense attorneys generally get their money up front. Like, wouldn't you? Most of your clients are criminals. Do you really trust them to pay you after the fact? What are the odds of someone paying you if they get locked up? So it's called a retainer, but it's the money you're going to get paid because you don't expect to get another dollar after a trial. You just don't. Some clients may, but generally speaking, as a criminal defense attorney, you get it all up front before you commit to the case. Carbonized Stardust. Science and math confirm he wasn't hit by the vehicle. Is everyone forgetting that? Science and math. That's the problem I have, right? That's the problem I have on the second count, because the second count still requires the SUV to make contact. And you didn't prove to me how it happened scientifically. And the other side called someone who they didn't pay, who said it couldn't have happened. And they're pretty credible guys. So, yeah, that's a big issue. That could be a hang up. But right now, at least today, based upon what they said, it's about the crime scene. A case in Scotland took 13 minutes to get to a guilty. Well, were the pubs closing in like 15 minutes and they had to get out of there? Thank you, Daisy Boo. That's interesting. 13 minutes. That's got to be close to a record anywhere. Thank you. Maria Hastings. Vinny, if they come back with a hung verdict, do you think the prosecution will retry this case? Yes, they will. They will attempt to get a deal. But they will absolutely not just dismiss the charges. Yobi, shortest deliberation on record is 60 seconds. Be interested to see what the charges were there. The basic picker. KR and JO fight. Jo tries to exit against KarenRead's will. KR pulls forward. John gets out. KR starts to leave, reverses 24 miles an hour. Jo sees it coming, throws or hits the glass on the taillight, tries to get out of the way, trips on the curb, loses, the shoe falls off, smashes head on the back. That's a not guilty. Or it could be leaving the scene. Interesting analysis. And that is based upon your perspective, as possible as anything else. No eyewitness. Okay. Robert is always busy giving us lots of information. Robert, tonight. Also, video got more information. That own court TV and NBC News, Boston, Massachusetts, Bob Warden, Inside Edition, A&M is scheduled to report on the case at 7 p.m. and 4 p.m. tonight. Thanks for the update, Robert. Always appreciate you being here and being attentive to what's happening there. Bob Ward, great reporter up there in Massachusetts. He's a good one of my favorites. All right, I'm almost caught up. Danny, what if anything kind of can you explain based on your education sort of happened and stuff? I think you're being facetious. Thank you, Danny. Jamie Heather, JD, she's a lawyer, Massachusetts attorney here. Judge chose foreman. Then they drew the alternates. Isn't this the judge choosing to save the foreman and dictating part of the jury pool by ensuring he doesn't become an alternate? Not okay, says Jamie Heather, who is in fact a lawyer. And the other thing is, we cover cases all over the country, and the foreperson and alternates, all of that is done differently from courtroom to courtroom, jurisdiction to jurisdiction. Thank you, Jamie. Does this show you need money to defend yourself? Asked Paige Price. It helps a lot, especially with the investigation. Kathy Gidry, sorry if I missed this part. Did they identify the car owner at the flagpole morning of the scene of the snowplow dryer? The alleged Ford Edge? No, it wasn't. If it was a Ford Edge, there was an argument about who it could have been, but there was no positive identification done. Michelle L., I agree. Cameras. I want to see for myself. Absolutely. Laura Delaney, hearing the voicemails. I don't believe she's guilty of first degree. She was drunk for sure. If she hit him, I don't think it was intentional. That is count 2, perhaps one of the lesser includeds. Laura, June, I couldn't be a juror. It's too much. It's not easy. Risa with a super sticker. Thank you, Risa. Thank you for smiling. Love it, love it, love it, love it, love it. All right. Yep, that was me. If I was convicted, if I wasn't convinced of conspiracy, but I'm just as convinced that she didn't do it, I think drunk accident, that would be somewhere lesser included, count 2. A lot of people landing kind of where I am on this, on my debate. Nina, much love from Georgia. Vinny, thanks for all you do. Victims of violence. Thank you, Nina. Georgia is awesome. That's where I am. Albert, I am convinced the Sallyport video is heavily edited and doctored. There were mistakes made and fixed, but some were not fixed. If the jury believes that, they've got to vote not guilty if they believe stuff is altered and doctored. Chloe Albert's revenge. People always want physical evidence, and there is none. This time there is. His injuries are not from a car, and everyone is judging Karen's personality and demeanor instead. Talk about irony. Irony. Pascal Fortman. Vinny, we need a tangent show. The evidence is clear that she hit him and left in a rage, not sure about her awareness. Tangents should be on Friday. Could be verdict day. We could have the tangents on for the verdict. Why didn't Jen run in that house for help? Asked Tawanda. That's what Tawanda is wondering. Why did she not run into the house for help? Interesting, right? Gringa, or maybe just a few people conspired, others believed them and made the evidence fit after the fact, is what I believe you were saying there. Warsaw, Buonasera Vincenzo. What happened to the case of the brain neurosurgeon who lived in that massive mansion that was supposedly killed by a lover? Where is that going? Very interesting case. Any news? We are following that story. I do not have the latest at the tip of my tongue, but it will be addressed on my show at some point. Thank you, Warsaw. Scooter, if the jury hangs, do you think the judge will issue an Allen charge? Allen charges are very dangerous. It'll be a soft Allen. I call it a soft Allen. Tishku, loving you in this format. Been with you since day one on Court TV. I'm not convinced there was a conspiracy. She hit him. Her father gave an interview detailing. She said she hit something. All right. Thank you, Tishku. And Debbie Rose. Hi, Vinny. Could you please look at the side-by-side, 102, 142, the back of the vehicle? To me, they are not the same shape, especially the back windshield. Interesting. I'll make it big again for you. Take a look. There it is. Thank you, Debbie Rose. I'm trying to catch up. I try to hit everyone, but I'm not going to have time today. Murfetts, for your information, Duty Ron and Ed Wallace and the lawyer, all say not guilty, reasonable doubt. Duty Ron, Ed Wallace, absolutely disgusted. Duty Ron says it's some shady. Absolutely. You got to trust Duty Ron. Duty Ron calls him the way he sees him. He knows he's walked the walk. Marty's with us. Vinny, would you eat at a restaurant called Aunt Bev's Side Bar and Grill? Of course I would. And I'd want to have a lobster roll if I went there. Mega 3 Cats, thank you. This is the lightning round, folks. I'm trying to get through it. Deanna Bellina, the reconstruction medical experts say he wasn't hit, including 70 people didn't see him. Luckily, I don't understand how anyone can be guilty. It is surprising with all the people looking out the window, all the people showing up, that no one witnessed this. Is it possible nowadays that a fair trial is a jury safe? Yes. Our system works. Chloe Albert's revenge. When people say too many people for a conspiracy, I submit this is not true. When people try and fail, we get this case. When it's successful, we never even hear about it, and people don't believe. Great point. We don't catch the smart ones, right? All right. I'm trying to get through this all. Michelle Joyce, is the jury aware of fan support for Ms. Read? They might be. They might feel it. They might sense it, but they are protected from seeing the protesters outside the court. Action Benz, Canton resident here. I think people had actually experienced Massachusetts police officers up close. They would understand the conspiracy is real. Stay safe, Action Benz. Stay safe. And don't forget to go to CF McCarthy's. Great menu. Love that spot. Waterfall's pretty strong too. Above and Beyond Ancestor readings. Wait a minute. Those photos of the car. The back wiper is moved. What if it was towed? All right. Maybe he threw the glass of the car, got her mad, and she reversed to 24 and clipped his head. Not impossible. McSpunky present. We can end the stream. McSpunky is present. We can end the stream. I'm proudly free. KarenRead says M&T's yeah. I'm nervous. You should be nervous. You never know what they're going to do. So, Robbie, here's the simple. Do you believe the injuries in Jonathan's body are consistent with 24-mile-per-hour impact? Yeah, not from what the experts told me. That's a problem. And that's the problem I have. Johnny T. Thank you, Johnny T. We're almost at the end. Albert, I feel better if the defense exposed more of the Sallyport video. It'll be easier to see the theory of the cover-up, not just timestamp and apparition. Yobi Trice. It's a little ridiculous that another picture of me tried to argue Karen not calling 911 right away is evidence of guilt. Karen thought he was cheating at first. Yeah, you don't call 911 if you think someone's cheating. Imagine if everyone called 911 when partners are late. Yep, that was me. And I am officially Johnny T. Will Trooper Park to be fired after this? I don't know. We're talking about it on the show. What happened with potential perjury charge of the witness? I don't know. There's going to be any charges for that. I wouldn't wait for that. Vinny not going to say guilty because people get mad at him. Can't blame Vinny. Vinny not going to say guilty. Vinny just being honest. Vinny's just being honest. All right. But thank you, Rescue Reaper. Nice picture. McSpunky still here. Allie Taylor. Questions. Deliberations are they done for the day? They are done for the day. And so am I. No way, says Marianne Ponte. Were they going 24 miles an hour? Why wasn't her interview on TV played in court? It's hearsay, maybe. Invite Peter, lawyer on your show. He'll be there. All right. That's the end of the show. I got to go. 8 o'clock tonight, Court TV. More than 9,000 today. Thank you. I'll be back tomorrow. The verdict watch continues. Like, subscribe, hit the bell, and don't forget,